sentencing in your brief, Mrs. Okazu?
Yes, Your Honors, and I was just that if Your Honors allow me, we move for the maximum sentence. We did so in our brief.
All right.
Life sentence, Your Honor.
Thank you. Professor Hinds. May it please the court, Judge Mose, Judge Ugaroff, Judge Aray, Ms. Okali, Mr. Maweri, Colonel Setako. Your Honors, the defense has made written submissions of our closing brief, which outlines the defense's contentions with respect to the jurisprudence that we believe controls these proceedings. These include, among other things, the burden of proof, the nature and assessment of the evidence, and applicable principles of individual and superior responsibility. Therefore, we will not address these issues during our oral arguments. Furthermore, to the extent that during these oral arguments we do not address any of the issues contained in our defense closing brief, the defense does not waive these arguments, but considers them submitted. Finally, Your Honor, our calculations, we intend to limit our time to 2 hours and 75 minutes. I'm sorry, 2 hours and 45 minutes, because that is what we thought would be the time frames given the starting times. I intend to use 2 hours, and my co-counsel, Mr. Kanek, will use 45 minutes in his portion. And he will address some of the prosecution's rebuttal to the defense closing brief, especially in connection with the alibi testimony. I will focus my attention with respect to the substantive charges that have been leveled against Colonel Setako. Permit me, Your Honors, to make some general observations about the prosecutor's evidence in this case. I'd like to read a quotation from a chapter 2 in particular, of a book entitled Through the Looking Glass. Now, that was a publication over a century ago, some of you know. And the quotation starts as follows, in quote, "Now, here you see, it takes all the running you can do just to keep in the same place. If you want to get somewhere else, you must run at least twice as fast as that." End of quotation. Over a century ago, Lewis Carroll wrote a book called Alice in Wonderland. It's in 1865. He then wrote a sequel to that book called Through the Looking Glass, in which he describes a fantasy world where fantasy actually becomes reality. In this world, only Alice was the only person who questioned the fantasy. Everyone else who dared to enter the fantasy world believed the fantasy to be real. This trial is taking place before this international tribunal, and it is unique. Why do I say it is unique? As far as criminal trials go, it is unique because there is a parallel process taking place in Rwanda. That process is seeking to identify the Tutsi victims and perpetrators and accomplices of the mass killings that took place there and other crimes that unfolded during 1994. These are crimes that took place at the cellular level, sectors, communes, and within all of the prefectures. These proceedings are called gacaca proceedings. During the investigatory stage, investigators conduct a cellule by cellule canvassing to identify all Tutsi victims and the circumstances of their deaths or other injuries. And they also are attempting to identify the names of alleged perpetrators and accomplices. This is then followed by a trial phase. Your Honors, there are obvious crimes that the population at the cellular level would be unaware of. These would be the crimes in the suites, SUITES, the conspiracies, the plannings that go on behind the scenes. But then there are the crimes in the streets, the common crimes, the killings, the inciting, the burnings, the lootings. These are crimes that the common people know about, and therefore would be in a position to identify the perpetrators and identify those individuals who acted as accomplices. Consequently, at the gacaca proceedings, one would then expect that a certain level of criminal activity would be reported. Now, under the rules of the procedures of this tribunal here, the ICTR, to ensure maximum protection of witnesses, we provide, and the rules provide, that Witnesses can testify under a cloak of anonymity. But this could be a double-edged sword. Witnesses know that they can come here and tell a story freely and anonymously about facts that they say occurred in Rwanda without being challenged by anyone back home, because nobody knows what they said. Sometimes the allegations are pure fantasy. Therefore, it is incumbent upon us who are here seeking to find out the truth to behave like Alice and to ask the questions. If these acts occurred, as you said it occurred, Mr. Witness, why hasn't it been reported by anyone in the general population in Rwanda? Why didn't you report it? If you said that Colonel Setako committed certain acts in public of such notoriety, why hasn't anyone else in Rwanda, in various jurisdictions, reported this? Mr. Setako's defense suggests humbly to this chamber that there has been an insufficient amount of thought and inquiry given to an examination of the impact of the Gacaca proceedings on the search for truth right here at this tribunal. Therefore, it was in that context that the Setako defense introduced Gacaca documents. It is in that context that we called an expert witness to testify concerning the crimes that allegedly were committed by Colonel Setako. And if they had been committed, should they have been reported in the Gacaca proceedings? A very, very important and fundamental issue in the search for truth. In my 35 years of practicing criminal law, I have not been in another proceeding where in one tribunal we are dealing with certain facts, and in a parallel tribunal the same thing is happening, and no one is from each asking, guess what? How come someone who comes from one community here is giving us one story and they have not said anything about it in another? Now, we could proceed in a very ostrich-like fashion and say, well, our jurisdiction is simply here, and so therefore what is happening there, unless it's brought to our attention, etc., we will not deal with it. The defense here suggests, Your Honor, that we should deal with this contextually, and in our closing brief, we pointed out contradictions, inconsistencies, and evidence which are uncontradicted, which establishes that allegations made by some prosecution witnesses simply are not true. Now, the prosecution, and Ms. Okali today, talks about a joint criminal enterprise. I'd like to start there. In our closing brief, the defense has argued that the prosecution has failed to meet its burden in establishing beyond a reasonable doubt, A, that a joint criminal enterprise existed, B, that Colonel Setako was a participant in that joint criminal enterprise. We have further argued that the prosecution's proofs do not meet as a matter of law and prove that Colonel Setako had the necessary actus reus with respect to the commission of that particular crime, nor have they proved that Colonel Setako had the requisite mens rea. They did not, through any of the admissible evidence, prove that Colonel Setako had the criminal intention to participate and to contribute to the criminal purpose, knew that certain crimes were being planned and committed by the individuals in the enterprise. In other words, they have not proved that Colonel Setako was aware of the possible crime and the consequences of this so-called joint criminal enterprise. In his closing brief, the prosecution advanced, or at least claimed, that 4 witnesses, or that they were relying on 4 witnesses to make their case. The witnesses they identified and whom we accepted as true was SAE, SAW, SBI, and SSB. SAE was never called. Now, with respect to SAW, SBI, and SSB, we have laid out in our closing brief, I do not intend to rehash here, but they simply failed to establish through any admissible evidence that they gave at this trial that they were aware of Colonel Setako's involvement in any joint criminal enterprise. So their testimony, looking at it in a light most favorable to the prosecution, simply fails to establish that proposition. But we didn't stop there. On a prudent note, we decided to provide an analysis of all of the prosecution's witnesses who purported to testify concerning a meeting that occurred the evening of April 6th and the morning of April 7th at Zerera's mother's house. And we then looked at those witnesses. There were 4 of them. And we again, in our brief, provided an analysis with respect to those witnesses. They were witnesses S-AA, S, A as in apple, M, Sam, S, M-A, and S-Q-G. The prosecution, as Ms. O'Calley indicated earlier today, pins most of their case on the JCE on witness S-AA. S-AA is a witness whom she has described as a credible witness. We have laid out in great details why we believe, and the evidence shows, this witness is a witness whose testimony should be viewed with great caution. We have not gone so far as to suggest that any of these witnesses' testimony should be thrown out. We are not saying that. We are saying that, one, given that this witness was an uncorroborated witness with respect to critical material facts, B, that he was a convicted felon serving a sentence in prison, that under the jurisprudence of this tribunal, that such a witness testimony, if uncorroborated, should be treated with caution. That is all we're saying. And it is for you, judges, who are triers of the fact and judges of the law, to give whatever weight you want to give to the witness's testimony. Now, we are told that my learned friend wants to admit the judgment. I have not read through it, but my inclination is to say yes, admit it, because it goes to motive, the very issue of why someone who is a convicted felon serving a long sentence, why would that person testify if they do not expect or want to have their sentence reduced? This is a man who is like the Greek mythological figure, lying with the sword of Damocles over his neck, a sword that is hanging by a cobweb. You recall the testimony of SAA. When asked, would you lie in order to save your skin? He said yes. There is no question about it that this is a witness who, if you look at the totality of his testimony, was not just prepared to lie to anyone. He was prepared to tell an untruth, to present a false document, to present a document that he knew to be false. To whom? To judges. Why? As he said, if it will help me, yes, I will do it. No matter how the prosecution spins it, the evidence is there. His testimony has to be weighed, we submit, with great caution. But the witness did something else. The witness came into this court and accused lead counsel of going to Rwanda disguised in some way and influenced the Gacaca courts that handed down the sentence. As the court knows, I took great umbrage to it and wanted to file papers, etc., challenging this testimony. But the chambers ruled that it wasn't necessary. I let it go. But this court should pause in evaluating a witness's testimony to take into consideration these facts and to weigh it in the context of the witness's testimony. We have gone through great details in discussing the witness's testimony, the prior testimony, etc., concerning whether or not a meeting of the gravity that this witness talks about occurred. Now, much has been said about the culture of Rwanda, where witnesses answer questions put to them almost like in surgical manner. A question is asked about X, you answer that question about X and not about Y or Z. But whether a meeting took place is not such a question. Whether a meeting took place which was a predicate to the mass killings that took place in this location of Ruhengeri Prefecture. And the meeting was, in fact, participated by a number of individuals, including the witness. The witness, in previous statements given to Rwandan authorities, statements that he gave to Gacaca investigators while he was in prison, mentions nothing about it. Question is not, did you see X? And the witness says, yes, I saw X, but didn't mention Y. The question was, what were the activities that took place in the particular locale concerning the preparation, planning, killings, who were the accomplices, who were the killers, and so on and so forth. No mention of this meeting. We tendered certain exhibits, D1 and D3 to D13. No mention. Now, this trial chamber, we believe, must ask the difficult questions and the very telling questions. Why, if such a meeting occurred, that there was, and but this was a meeting which was preparatory to these mass killings, why there was no mention to it. So if we look at SAA's testimony in connection with the JCE, and that's all we are talking about here, it is insufficient. Now they produce another witness, SAM. Now what does SAM have to say? SAM, who supposedly was going to testify about what happened at the meeting, to corroborate SAA. Now, who is SAM? SAM, another convicted felon, serving a 30-year sentence. He came to court also, and as if it was a plan, accused lead counsel of jeopardizing or threatening his family back home. Again, the chamber, in its wisdom, said, Professor Hinds, we understand. You don't need to conduct any independent inquiry. Because the witness said that I came to the prison, saw him, I was hiding behind a big cap, and on and on. Again, we believe that the witness's credibility has been impugned by his willingness to come forward and make the kind of baseless charges and accusations before this very tribunal. Now, Sam's testimony, in the most part, was uncorroborated. He talks about seeing Setako and Kajeli Jelly the evening of the 6th at Zerera's mother's house. SAE doesn't talk about that. But then he claimed that he went on a drinking binge. And when he woke up, he was not at Zerera's mother's house, but at somebody else's house. He doesn't know what happened at the alleged meeting on the morning of April 7th. All he knew is that he got up between 4 and 5 in the morning, and he was elsewhere. So much to this witness's testimony concerning this meeting of the 7th and the evening of April 6th in planning and preparation for the mass killings. SMA. SMA was the only individual who, again, uncorroborated testimony, SMA claims that he was in the Biangabo market and saw a convoy of cars sometime around 8 or 8:30 in the morning, and that Colonel Setako was one of the individuals who was in one of the cars, leaving the vicinity of Zerera's mother's house. That was his testimony. When other prosecution witnesses were asked, did you see a car? Did you see a convoy of cars that morning? What was their answer? No. Who were the witnesses? SAW, SAQ, SAA didn't testify about it. So, what do we have concerning this so-called JCE and meetings that occurred? And Ms. Sokali, my learned friend, is absolutely correct. Rests on the shoulder of the weakest link, SAA, with respect to whether or not this meeting actually occurred. SQG, while he was listed in the pretrial brief to talk about weekly meetings that occurred at Guerrero's mother's house, again in preparation for these killings, talks about a meeting that he said occurred sometime in 1992, and he himself didn't attend the meeting. He was told about it. Now, what type of evidence do we have in order to convict Colonel Setako of being a member of, participating in, a joint criminal enterprise? This is the quality of the evidence that we have concerning this particular issue. Now, if we look at all of the witnesses that the prosecution proffered, that is, those they listed in the pretrial brief, and those whom we decided to analyze their testimony based upon what the prosecution said they would testify to, SAE, SAW, SBI, SSB, and the four witnesses that we just discussed their testimony, they advanced the prosecution's theory with respect to the JCE, zero, nil, nothing, no basis, not with respect to admissible evidence in this case. Now, let me proceed just to touch on a couple of other issues that we want to talk about.
And we will do that at 3 o'clock.
Oh, okay.
Court is adjourned.
All right.
Please be seated.
Professor Hinds.
Thank you, Your Honor. I'd like to just address very briefly a couple of other points. The prosecution in their pretrial brief said that they would prove at trial that Colonel Setako had prepared lists of Tutsis for elimination. We addressed that in our closing brief, but suffice us to point out that there were only two witnesses that the prosecution claimed who would be able to establish those proofs. Again, they were SAA and SAM. With respect to SAA, we pointed out that he claimed there was a meeting at the Mukingo Commune office in 1991 when at least there was in attendance Colonel Setako, and at that meeting there was some discussions concerning preparing lists of Tutsis to be eliminated. Aside from the temporal jurisdictional issues relating to that allegation, when the witness was asked, I think by Judge Ilgarov, whether or not that list was used in 1994, he said no. Then there was SAM. SAM, at least the prosecution claimed in their pretrial brief that he would testify to the fact that Colonel Setako asked him to prepare lists of Tutsis to be eliminated. Of course, he took the witness stand and said to the contrary, that because they couldn't come up with any lists, they gave Colonel Setako some names of individuals, including Semisabiki. So there is no testimony at this trial that Colonel Setako requested or ordered others to prepare lists of Tutsis for elimination. Now, I'd like to address an issue concerning the establishment of military training and supply of weapons to the Amahindure and Interahamwe groups.
And please do that. I just want to place on record that the reason why we started 13 minutes late was a technical problem. And then we carry on.
Thank you, Your Honor. The prosecution offered 14 witnesses to establish this point. We addressed each and every one of those witnesses in our pretrial brief. In our closing, defense closing brief. We do not intend now to go over the testimonies of all of them, or in fact any of them at this particular point, but we simply want to note that we submit on the papers that we have prepared and the arguments that we have prepared in this regard. With respect to each of those witnesses. In addition, we have addressed whether or not a meeting took place the evening of April 6th and the early morning of April 7th at Zerera's mother's house. In our arguments with respect to whether or not a JCE was established. And so therefore we do not intend to rehash those arguments nor provide any analysis with respect to those witnesses who testified there. Except to remind the chamber that a witness, GFA, who offered testimony in Government 1, and for purposes of this trial, we admitted into evidence portions of his testimony when he recanted, testified specifically about the instructions that were given to certain witnesses to fabricate testimony and evidence in connection with certain meetings that allegedly took place as a predicate to the killings that subsequently followed. I'd like to address the issue of Bernard Bajagahi. As this chamber recalls, witness SAA claimed that on the instructions and orders of Colonel Setako, that he killed Bernard Bajagahi sometime in the early part of 1994. We are not at this point pushing the issue with respect to whether it was February or March, or the contradictions between the witness's testimony, pretrial brief, and indictment. We submit our observations that we made in our brief. But we'd like at this stage just to point out that the burden of proof is not on the defense. The defense does not have to prove anything. The burden of proof rests with the prosecution and does not shift in the procedures within this tribunal. And they have to prove, beyond a reasonable doubt, the allegations that they have made concerning the killing of Bernard Bajagahi, when he was killed, where he was killed, and whether or not there is any admissible evidence that Colonel Setako did it. So it is in that context we look at the contradictions and the problems with the witness's present testimony before this tribunal and his prior testimony concerning this. As the court recalls, on his direct testimony, he talks about Bernard Bajagahi from Shingoro. Once he realized that there was a document with the name of Bernard Bajagahi from Shingoro that reflected he was killed in 1991, what did the witness say? Oh, it's a different Bernard. I didn't really mean him, And so therefore we began to spend a lot of time looking at his prior testimony and so on. But it is clear that this witness made previous statements which were in conformity with the reality, and that Bernard Bajagahe was killed prior to 1994. Now, with respect to the allegations in this case, he attempted to shift. This court, I'm sure, will be able to unravel all of this and looking at the testimony. However, rather than relying upon the documentary evidence, the defense introduced, as this court recalls, a defense witness, MCP, who talks about the special relationship between him and Bernard Bajagahe and the circumstances under which he, as an eyewitness, knew that preceded the death of Bernard Bajagahe and where. So we didn't have to rely upon the document, although we tendered that document, which is now admitted as Exhibit D, as in David 188. I'd like to now address another issue that has been raised, and that is with respect to whether or not the prosecution has met its burden of proof in the allegation that Colonel Setako caused the death of a young Tutsi girl by burning with petrol in Mukingo commune. The problem with this allegation, and again we speak about the prosecution's burden of proof, we do not have to remind this court that the prosecution is obligated under the applicable rules of this court to prove each and every element of the case. Now, what do they say that they intended to prove? They said that they would prove that on the morning of April 7th of 1994, that Colonel Setako caused the death of this young Tutsi girl by burning in Mukingo commune. They produced one witness, uncorroborated testimony of witness SAM. Now, what does SAM say? SAM says that this killing took place not on April 7th, but on April 8th. What else? The killing didn't take place in Mukingo, but it took place in Nkoli. Now, can this chamber convict, assuming that the chamber considers the testimony credible, and we have challenged the testimony in our brief? We pointed out the inconsistencies, we pointed out the contradictions, and we pointed out why the testimony was not believable. Putting it aside, because I don't intend to rehash that here, putting that aside, as a matter of law, can the chamber convict a defendant where the prosecution says that the crime was committed on one date and the testimony at the trial is at a different date? In addition to that, the location is different. Now, this is not an isolated issue of whether they met the burden of proof, what is the prejudice to the defendant. The prosecution suggests that, well, the defense put up a vigorous defense. They produced witnesses who contradicted the testimony, etc. But the problem is greater than that. As this chamber recalls, there were 2 young women who were burned. We, throughout the pretrial stage, asked for particularity because we take our responsibilities seriously. We have to defend someone who's fighting for his life. The prosecution has a duty to lay out charges with specificity. They failed to do that in this case. The witness testified that the killings took place at a different place, different time. But we knew that there was a burning that took place in the Busogo area, in the Rankeri, in Mukingo. That victim was named Joyce. So during the prosecution's case, you recall that the defense was cross-examining very meticulously about that burning because we thought that actually it was a burning in Mukingo. Comes to find out that their witness now talks about a burning and a killing in Cooley. We submit that just based upon those defects in the indictment with respect to the testimony of the witness, which was at variance with the proofs in the indictment, that this charge has to be dismissed. I'm not going to go into the arguments that we have advanced with respect to whether or not on the merits the testimony of SAM is believable or not. We submit those arguments in the event that the trial chamber disagrees with us on the law. And so that submission is made. We now proceed to Fantasyland. Whether in the morning of April 7th, Colonel Setako ordered the killings of Zirawiwa and Imbambasi. Now, this chamber is quite aware of the testimony of witness SAL. SAL is an eyewitness. What was his motive? Well, he says, quite candidly, that he blamed Colonel Setako for the death of his father. I talked earlier about the double-edged sword and the problems with anonymity. Here is a witness who claimed that he was hiding in the bushes in a location near a particular roadblock called Surepara, and saw 2 individuals being killed. These individuals were being hacked to death, crying out for help. And according to this witness, Colonel Setako was standing nearby, doing nothing. Now, this witness testified not in public in Rwanda, where other people in the community could cry out and say, what you're saying is not true. He testified here under cloak of anonymity. And that is the problem in these processes, that troubles me as an academic, troubles me as a defense lawyer, and should trouble all of us here. Why do I say that? The objective facts through documents shows that these two individuals, Ziragwira and Imbambasi, yes, they were killed in Rwanda. Yes, they were killed in 1994. But neither of them were killed at Soreparao. Neither of them were killed involving Setako. Now, the documentation establishing that fact didn't come from defense witnesses who may have had some motive to lie and who came here and said, I was there and I saw this or saw that. It came from objective facts from what I call a parallel process. That is to say, events that took place in Rwanda during that time period, there were people who were identified as victims. Ziragwira was in fact such a victim. Ziragwira, yes, was a Tutsi. But Ziragwira was not killed at Soreparao. Witness SAL never attended the trial for individuals who were accused of the killing. He never, when he was in Rwanda, went and said what he said on this witness stand. If it occurred, you would think that, and people who were identified as perpetrators, objectively he would be able to say, yes, I was there, I saw it, I was an eyewitness, I told what happened. Nothing. No evidence. Now, the prosecution has a burden. It's their witness. If he, in fact, so testified, they would come forward with evidence and say, this corroborates what the witness said. Nothing. We are being asked just to accept this fantasy and act as if it is true. Within the documents introduced in this court, we have the judgment, and there are the names of the individuals who were involved. And I'm not going to go further with this, but it is part of our brief with respect to who was killed and the circumstances involved.
This person who testified about the killing of Ziragwira, was he a protected witness? He seemed to have been. Yes. We will then strike these words at 15:31:42. The sentence starting with now. We will simply say deleted and then came here. No, we will delete the entire sentence. Only one sentence from 15:31:42 to 15:31:48. Or 56. Until I came back.
Thank you, Your Honor. I'll be careful. in the future with respect to any reference to witnesses whose identity might be compromised. But moreover, there were Gacaca documents establishing the reality that such killings took place, but there were no Gacaca documents establishing that any killings took place at Sodeparal. Similarly, with respect to Mbambasi. Mbambasi, yes, was killed in 1994, but he was not killed on the 7th. He was killed some 4 days after the 7th, sometime around the 11th, and not at Sodeparal, but in the location where he lived. Again, objective documentation established that. So how do we square a witness who was not a convicted witness, not serving time in prison, and so we don't have that type of motive, but someone who came here and seemingly was grieving about his father's death, etc., coming and testifying so falsely? Can we, if we now see that this witness on these facts testified falsely, can we believe him with respect to other facts? Now, the jurisprudence of this tribunal is that, yes, you can build a Chinese wall, and the fact that a witness deliberately falsified testimony in one respect doesn't mean that he's falsifying it in another. That's the intellectual gymnastics that perhaps can be done. I would suggest that it raises caution flags. It raises caution flags. Now, concerning the meeting at Rukabu's house, I don't intend to go into the analysis that we provided to this chamber with respect to whether or not this occurred. But suffices to say that based upon the testimonies of SDA and SAL, if we were to believe both of these witnesses, SAL would have been able to see what SDA claims he saw going on at Rukabu's house. Because, again, we have the uncorroborated testimony of SDA that there was this meeting. We only need to point out, Your Honor, that the prosecution in their Exhibit P28C, which was a letter written in 2005 from SDA to the Ruangeri prosecutor, which he lays out a number of accusations. He never mentioned this meeting that he claimed took place at Rukabu's house, which was preparatory to the launching of killings in the area. Now, Ms. O'Calley referred this chamber to what she described as a contradiction in the testimony of defense witness NDU, where she says that NDU contradicted defense witness NDX. During the break, we had an opportunity to look at the transcript reference, which was May 27, 2009, page 35, and lines 18 to 31. According to Ms. O'Calley, the testimony of NDU contradicted that of NDX to the extent that NDX and other witnesses said that in 1994, Rukabu had moved his business to Gisenyi, that his house was abandoned, and that he was no longer living there. NDU was asked whether he knew Rukabu. And he says, yes, I knew Rukabu as a trader. And I knew that he had a business in Mukamira. But he also heard that he had a business in Gisenyi. He went further and says he, NDU, never checked out his business in Mukamira. He was asked about Rukabu's house. He said Rukabu lived in a neighborhood which was about 20 minutes from me if you take the tarmac route, and perhaps 10 minutes if you took some shortcut. But he said, I never frequently went to Rukabu's house. And the reason why I didn't do that is because there were no young people my age around there in that neighborhood. So he doesn't know anything about the Rukabu's house, whether Rukabu was there, etc. Knew even less about Rukabu's business, just heard certain information about Rukabu having been a trader. What Ms. O'Calley, my learned friend, latched on to is the witness said that he saw sometime in 1994 Rukabu driving by in a Hilux. Now, there is no testimony that Rukabu was banished to Gisenyi, that Rukabu could not travel the roads of Rwanda. The testimony is that Rukabu was not living in his house. His house was abandoned. He had moved to Gisenyi. There's no contradiction there. Now, SDA testified that he knew that Rukabu was a relative of Setako. That hasn't been proven. That's an outlandish statement. No proof, but that he knew that Rukabu was a brother of Setako. Let me touch on the killing of a young Tutsi male at the ICE roadblock. Again, I am not going to address the issues with respect to the merits. I'm submitting on those because we have dealt extensively with them. I'm raising a legal issue with respect to the evidence. This allegation was not contained in the amended indictment. And the reason why it's not contained in the amended indictment is because the prosecution, in a motion, moved to remove this issue, and they did so in a motion to amend the indictment, and as this chamber recalls, this allegation was contained at paragraph 20.3 of the original indictment. And the prosecution was granted a motion on December 18, 2009, to remove that allegation. Not in the indictment. Can there be a conviction of an allegation not contained in the indictment? The fact that the defense, on an abundance of caution, refuted the allegations, produced witnesses, etc., does not mean that we have waived a fundamental defect in the indictment. So we, as a matter of law, take the position that that defect was incurable, and if the chamber looks at the history with respect to the amended indictment, original indictment, we see that the accusatory instrument that governed this trial does not include that particular charge. There is an allegation concerning whether on April 11th, Colonel Setako ordered or instigated and abetted killing of Tutsis in Rwanda. This chamber said that that allegation should be subsumed within an allegation concerning the Court of Appeals. So we addressed both of those issues. And again, I do not intend to go into that at any length, except to say that with respect to the Court of Appeals issue, the chamber recalls our alibi. My colleague will be, co-counsel, will be addressing that in more detail, so I'm not going to take the time to deal with that. Let me briefly touch on Mukamira camp. The allegations made by witness SLA and SAT concerning Mukamira camp are such that gives or should give everyone pause. These witnesses describe massacres that occurred. According to these witnesses, all Tutsi refugees who had taken refuge at Mukamira camp were wiped out. That this was done on the orders of Colonel Setako. None of this, not one scintilla of evidence was established by the prosecution to show independently that there is documentation that these killings took place. At this trial, we've heard of killings that took place in Busogo. There are documents establishing that those killings took place. There are documents that establish that Rukara was killed. There are documents that establish that certain acts took place. But here you have 30 to 40 people allegedly wiped out. Nothing to corroborate this evidence. Nothing. No Gacaca documents, nothing. But not only that, the horrors of it. Bodies were left to rot. Dogs were eating the corpses. Horrendous. This is not an allegation that took place in secret, and nobody knew about it. Troublesome lack of evidence to corroborate this. Now we produced and called Tutsis who were in Mukamira camp. They had no motive to come here to save the life of a Hutu. They have no motive. We had NEC who testified. Her father was killed during the events in Rwanda. Her brother, who was a student, he was killed as an accomplice. And she said, yes, I was at the camp. No killings took place. Now that should give us some pause. When we listened, on the other hand, to prosecution witnesses who said, on the orders of Setako, we went through and we killed Tutsis, even the relatives of soldiers who had gone to the front. We killed them all. Question: what happened when the soldiers returned and found their relatives were killed? Well, that's another point. But that's the testimony that we're dealing with when Ms. Okali, my learned friend, says we have this evidence establishing these facts. We have gone into great detail with respect to this, and I'm not going to dwell more on that. With respect to the killings of 3 girls at the house of Janine, we'll submit. With respect to that, I do not intend to go into that particular issue. But let me just address briefly the killings of 2 Tutsi young women at the Pillage roadblock. This was the testimony of SON on the one hand and SQI on the other. Suffice it to say that there is no independent documentation that any such killings took place in or around Pillage on the in April of 1994. There is nothing, not a scintilla of evidence. Now, what do we have? We have SON indicating that this particular act took place. Colonel Setako came by, handed these 2 young women over and said to them, go ahead, Bajage. Go ahead, kill them. Again, we do not have the burden of proof. The prosecution has that burden. We try to get particularity with respect to the identity of the victims, etc., so that we could conduct investigations. They said they gave us all that they knew. But their witness came forward, SQY, and he said, I know the identity of these two young women. They were the daughters of Mahangari. When questioned on cross, did you confirm this? He answered, yes, 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 3 times. Now, he says somebody told him this, but he confirmed it. It isn't for us on the defense to establish beyond a reasonable doubt. That's not our burden. The burden never shifts from the prosecution. They have to prove the elements of the crime. However, there isn't any evidence to corroborate these witnesses' statement that these 2 young women, certainly not the daughters of Mahangari, being killed during that time period. Finally, SQY. SQY said he made an observation from a particular location. We showed not only photographs, but there's evidence questioning whether he could have in fact seen what he saw. Wasn't the credibility of our witness, either the evidence, pictures, etc., establish what could be seen or not seen. We introduced that evidence through him. Concerning the distribution of weapons at Sopecha, we are submitting with respect to that. The testimony about 9 to 10 Tutsis who were brought around May 11th to Mukamira and killed, that analysis should be considered together with the April 25th testimony. And we have advanced arguments to show that this did not occur. And it is more than just differences in what witnesses see or recall. The fact that these witnesses in any prior statements never mentioned that. In prior testimonies, they said no significant acts took place between April 15th and May at Mukamira. And yet they came here and said there were these mass killings. We are submitting on the other issues that we have raised in our brief. I do not intend to trespass upon the court's patience or time rehashing the arguments that we have made. I will just reserve 5 minutes of my colleagues' time. I think that we have until 5, and I'm going to stop here. And he's going to take, he's told me 45 minutes, and I will take the remainder of the time just to wrap up what I'd like to do. Thank you.
Thank you. Your position is then that this exhibit, which was suggested, tendered by the prosecution, you don't really have any objection, if I understood it correctly?
That is correct, Your Honor. In fact, we welcome it.
We will come back to the technicalities with the tendering afterwards. Mr. Lucia-Badou.
Thank you, Mr. President. Your Honors, lead counsel has discussed the defense's positions on most of the charges that were addressed in the brief and that formed the bulk of the case against Colonel Setako. I will simply discuss a few points that were addressed in more details in the prosecution's brief and in my colleagues' closing arguments from this morning. The first issue I want to discuss is Colonel Setako's alibis. Now, alibis are a fundamental part of an accused defense, if he has one, and Colonel Setako has, well, the way we framed it in our case, two distinct ones. One covering the period of 6 to 12 April 1994, and the second covering the period from 12 to 21st of April 1994. The prosecution has extensively discussed the alibis in both the brief and this morning's addresses. Mainly we submit because they are capital. If these alibis are believed, most of the case against Colonel Setako just vanishes. It is, well, I will start and discuss the two alibis and start with the one from 6 to 12 April. Now, it is true that most of the witnesses who came to testify about Colonel Setako's alibi for that first period are relatives, colleagues, and friends of Colonel Setako. Our submissions is that it may be a legitimate concern from the prosecution's point of view that these people are so close to Colonel Setako. Our counter-argument on that particular point is that it is completely normal that that would be the case. The week of 6 April 1994 was a week of holiday. Children were on vacation since Easter was just around the corner. The plane crash was an unforeseeable event, and it is not without logic that Colonel Setako would be at home with his children having dinner with friends when that event occurred. The prosecution is trying to convince us that the reason why Colonel Setako was having dinner with friends is because he's fabricating his alibi and that he needs people who would be sympathetic to his cause in order to support that alibi. He's having dinner with friends on the 6th in the evening. His daughter testifies that he comes in with his friends in questions around 6 p.m. She testified that they stayed throughout the evening and left after they had all witnessed or heard the terrible sound of the crash. That friend, Mr. Yakaremye, essentially testified to the same thing. He arrives around 6 p.m. They have dinner. Dinner is interrupted by that crash. They look for information, and eventually Colonel Setako takes Mr. Yakaremye's family back to his house, circles a bit in town looking for information, and comes back home. The prosecution is arguing that there are notable differences between the accounts given by both Mr. Yakaremye, Colonel Setako, and the daughter. We submit that these differences really are not all that important. They essentially pertain to whether or not Colonel Setako was dressed in a uniform when he came back from work with his guest, about the time exactly where they left from the house to go and drive Mr. Yakaremye back to his house across the city. 13 years have lapsed since these events. Even more than that now, 15 maybe. It is not completely surprising that these level of details would not be found in the recollection of a 12-year-old or of a friend who hasn't actually really thought about the events since then. The key points, the timing, the events itself, are all the same in these three witnesses. And this, we submit, is what the Chamber should focus on. One other element is that if we believe the prosecution and that alibi was all fabricated, I'd like to point out to the Chamber that if Colonel Setako had left Kigali for Rwanda after the plane had crashed and after he had, to some degree, ascertained what the events were, then he would have departed no earlier than at least 2,200 hours, bringing him to Rwanda 2 hours and a half, 3 hours later, and it wouldn't have been possible for him to be there, as SA testified to, by 11 p.m. Now, the prosecution's position is, to us, slightly strange. We are just going to say that the reason why these alibi, or this alibi, shows these few minor inconsistencies is because it is true. Had it not been true, these inconsistencies probably just would not have been present. Now, the prosecution is also arguing that Colonel Setako's alibi is incredible because on his way back from Mr. Yakaremi's house, he went by the General Staff Headquarters and the Ministry of Defense to inquire as to what was going on, but did not take part in the meeting that was taking place at General Staff Headquarters at that time.
We are losing words.
I'll slow down, Mr. President.
You must slow down. Thank you.
The first point is that Colonel Setako was not invited to that meeting. The evidence that is in the case suggests that people who arrived at the General Staff had been called to take part in the meeting. It would have been extremely surprising for an officer like Colonel Setako to just rush in and take part in the crisis committee meeting of 6 April in the evening without having been invited to do so. After that, the OTP suggests I'm losing track of where I am. The meeting of the following morning, which the prosecution is also suggesting that Colonel Setako should have attended, was actually attended, according to the evidence, by his superior in his capacity as Director of Administrative and Legal Affairs. And I refer to you on that on Exhibit P86 and D173. Division heads, like Colonel Setako, were not asked to participate in that meeting. Colonel Setako instead just went to work at the Ministry of Defense like he would have at any other day, since they were, in any event, a red alert calling back everybody to their post. The prosecution is suggesting that Colonel Dibwami, Colonel Setako's superior, was not a lawyer and should not have been the only one present, and argues that there is some sort of obligation that Colonel Setako would have had pursuant to, I believe, Article 86 or 82 of the Geneva Conventions. Well, two things. First of all, there is no evidence in the case that such an obligation actually befell on Colonel Setako. We are, moreover, suggesting that if there was someone upon whom such an obligation could have fallen, it was not Colonel Setako, but rather the legal advisor to the Ministry of Defense, whose name was Ephrem Setako, EPIPHANEYURWIMANA. Now I see that they've written that in one name. It's Epiphan, and after the NE, there should be a break, and then the last name, Hanyurwimana. His name can be found on the first page of Exhibit P86. We will also argue that the fact that Colonel Setako was not convened at that meeting is actually a positive element that diminished the importance that the prosecution seems to insist that he had. Had he been the man the prosecution says he was, possibly indeed he would have been called upon to participate in those meetings. The reason he was not is because he's not the important man they say he is. Had there been, and I'm coming back on that point, an obligation on Colonel Setako, pursuant to Article 82 of the Geneva Conventions, to provide legal advice in a time of crisis to these committees, well, then the prosecution should have proven it. This is the first time we're hearing about it.
You see, you force these court reporters to go back to the tape with this speed, and then they have to sit to 8 instead of sit to 6:30. Wouldn't it be better to, now on the last day, to slow down?
I apologize. I will try again. Now, Colonel Setako also testified that he'd spent the remainder of the week running from 6 to 12 April helping friends in need and waiting in his office for instructions as to what to do. Obviously, his regular duties were not active anymore. Couldn't be filled anymore. It's not exactly true that, sorry, I'm losing track here. The prosecution, is claiming that there is fabrication because Colonel Setako stayed in his office and didn't do much when his position would have warranted a more intense involvement. But the evidence in the case is not that. Colonel Setako said that he had duties to fulfill, but that he could not fulfill them because the country was in chaos. Instead, he waited until he had instructions and then went on a mission on 12 April. In the meantime, he used some of his free time to assist some of his friends who were having problems. One of these friends was witness KAM. KAM testified that Colonel Setako took his mother, or her mother, to a clinic 4 mornings in a row, taking each day about an hour to do so. The prosecution again is arguing that this is a fabrication, as such a clinic could not have been open. There is no evidence that clinics were not open. The only evidence in the case coming from witness KAM and from Colonel Setako is that the clinic of the National Bank of Rwanda remained open a few days following the crash, and that there was personnel to provide care at that location. The prosecution is also arguing that KAM should not be believed because, for instance, she could not recall the brand of the car in which Setako came to her house. I'm asking this chamber, how significant can that fact be? 15 years later, the woman does not remember what brand of car she went to the clinic with? These testimonies, generally, and I'm talking about KAM and KAF, and Solange Akageneza, and David Biramahire all establish that Colonel Setako was in Kigali from 6 April until 12 April and did not set foot in Rwanda. Now the prosecution, and we're really happy to hear that, conceded this morning that Colonel Setako was in Kigali at least from 8 April and on. And I hope this trial chamber has noted that. Now, moving on to the second part of Colonel Setako's alibi. The second part of the alibi relates to a mission that Colonel Setako undertook on 12 April 1994, and that took him to Kinshasa. The prosecution, again, submits that this is a fabrication. Yes, there are differences between the accounts given by Colonel Setako, witness Nzabona, and the witness statement or testimony used during cross-examination and coming from Dr. Bizimungu Casimir in a different case. We submitted this is normal. There are differences between all these accounts on a certain number of points. That they went by helicopter from Kigali to Gitarama, where Dr. Bizimungu was picked up, or that Dr. Bizimungu met with Colonel Setako in Gisenyi. One of the accounts, Colonel Setako's account, indicates that he went to Badolite, was heard by President Mobutu, while Bizimungu, in his own case, indicated that he was the only one who was granted audience. We submit to this chamber that contrary to what the prosecution is suggesting, these differences are not on key elements, and that actually they rather credibilize the alibi. Colonel Setako had the transcripts of the testimony of Dr. Bizimungu in advance. If he wanted to fabricate a story about how he went with Dr. Bizimungu to say President Mobutu, if he wanted the accounts to be exactly the same, he could have done so. The prosecution is suggesting he's lying anyway. Might as well make it exactly the same. The reason it's not the same is because we're dealing with people's recollection. Colonel Setako is telling the truth as best as he can recall. The key elements are still there. On 12 April, Colonel Setako and Dr. Bizimungu took a plane from Goma, after crossing the border, to Kinshasa, spent a few days organizing, with the help of Mr. Nzabona and the ambassador, a hearing with President Mobutu. Were granted that hearing, took a plane to Badolite, met President Mobutu, flew back, spent a few more days in Kinshasa, and then flew back to Goma and made their way back to Kigali. Colonel Setako might have left Dr. Bizimungu behind. He might not. The recollections are not the same on this point. But the fact remains that from 12 to 21st of April 1994, Colonel Setako was out of Rwanda. To strengthen that last point, we have submitted two exhibits, D-181 and D-182. The prosecution is also apparently seriously suggesting that the very long arm of the almighty Colonel Setako reached all the way to Kinshasa in order to create computer records of an international chain of hotels in order to help in securing that fake alibi. I will leave the chamber decide whether or not that makes any sense or not. I would now like to move on to a second point that the prosecution had addressed in their brief and that the defense had not. And it is the question of the assassination of Pastor Semi Sabike and his wife. This morning, my colleague Mr. Mawere dealt with some of the issues of notice and defects in the indictment. He went over the brief that the defense produced and tackled each and every one of the points that we had raised in that category. The reason I suspect that he did not raise that one is because we had not. The prosecution, on the other hand, did so. Now, a long time ago, once upon a time, one may say, an indictment against Colonel Setako did include a charge alleging his involvement in Pastor Semi Sabike's death. Paragraph 20.5 of the indictment of 22nd of March 2004 clearly indicated that on 8 of April 1994, in Gitwa sector and Kuli commune, Colonel Setako ordered Interamwe to kill the wife of Pastor Semi Sabike, and that when Pastor Semi Sabike objected, Ephrem Setako ordered that he be killed as well. But in June 2007, when the prosecution requested leave to amend its indictment to add a certain number of new counts, it also decided that it did not have the evidence to support that paragraph and withdrew it. It is no longer present in the final version of the indictment filed in June of 2007. A little bit like with respect to the death of that young Tutsi man in front of Isae, the defense was somewhat taken by surprise when, on 11 September 2008, witness SAM started describing those events. Now, it is true that a summary of the expected testimony of prosecution witness SAM did make a one-line mention, and I refer to you to page 13 of Annex A of the prosecution pre-trial brief. A one-line sentence buried in the middle of about 40-line summary. But be that as it may, the fact remains that it was not included in the indictment, and nor was it included in the main part of the pre-trial brief, where in pages 32 and 33, the prosecution laid the factual allegations supporting count 3, murder. That contradiction comforted the defense in its belief that the prosecution was not charging Colonel Setako with those assassinations anymore. We submit that that sort of uncertainty and its impact on the ability of the defense to lead meaningful investigations prior to the beginning of the trial is exactly what led the appeals chamber in the Niyitegeka and Gvoka and Al cases to acknowledge that if the defense is not properly notified of the material facts of the accused's alleged criminal activity until the prosecution files its pretrial brief, it will be very difficult for it to conduct a meaningful investigation prior to the commencement of the trial. And I refer to you to paragraph 194 of the Niyitegeka Appeals Judgment, dated 9 July 2004, as well as paragraph 28 of the Kvoka Appeals Judgment at the ICTY, dated 28 February 2005. Now, we're not dealing with a case where the evidence unfolded in a way that the prosecution did not expect. Not here. It is a case where the prosecution withdrew a charge, led the defense to believe that this was no longer something they were contemplating proving, and then brought the evidence anyway. Now, the defense maintained throughout the trial a standing objection to all evidence coming in that fell outside the scope of the indictment. That standing objection was renewed from time to time. It was renewed on 11 September 2008, pages 37 to 41, when witness SAM started discussing the assassination of Mr. Sabisabike and his wife. Because the charge had been withdrawn from the indictment, the defense was not in a position to present any evidence. The prejudice caused by the prosecution's attitude in this particular matter is back and forth, cannot be clearer. The appeals chamber's comments in Niyitegeka and Kvoka we submit cannot be more to the point. Certainly the accused is not expected to defend himself against crime he's not being charged with. Despite that, when the prosecution filed their closing brief last month, it included at paragraph 92, under the heading Mukingo, despite the fact that the murder appears to have been committed in Nkuli, a development about the death of Pastor Sabisabike and Colonel Setako's alleged involvement in it. In the circumstances described before, the defense has a hard time understanding how that insertion could have been made in good faith. The prosecution purportedly withdrew that incriminating element from its indictment, slipped it back in a summary in the pretrial brief, and literally ambushed the defense by bringing the evidence during trial. We submit that it would be unfair for the trial chamber to find Colonel Setako guilty of that charge under the circumstances, and that it should be, as a matter of law, dismissed. Moving on to another point. Earlier today, the prosecution, and this is a very simple and straightforward point, the prosecution made comments about the fact that the defense had, in its pre-defense brief, indicated an intention to prove through witness Harelimana that witness SAF was not in a position to observe events unfolding at a roadblock located in front of the prosecutor, the general prosecutor's office, from his hiding spot in the gardens of Hotel Kiyovu. Just to rectify the record, the defense would like to point out that the reason it did not ask any question to Mr. Harelimana about that point is simply because the problem with SAF's ability to observe what he said he observed had already been completely negated by the testimony of witness SQY, who on 18 February of this year, at page 25, lines 12 to 17, and pages 28 to 30, pursuant to questions put to him by Mr. President, indicated that the distance between Hotel Kiyovu and that particular roadblock were such that the observation allegedly made by witness SAF was impossible. Finally, the defense would like to make a few observations about what could be called the characterization of Colonel Setako as it was made, by the prosecution in its closing brief. The first 12 pages of the brief, out of about 70, concentrate exclusively on who Colonel Setako was, not what Colonel Setako did. They made representations about the various positions he held, the people he knew. It almost appears as if the prosecution was trying to make sure that this trial chamber focused as much as possible on who Lieutenant Colonel Setako was, according to them, rather than on what he allegedly did. Now, we submit that this clear attempt at diverting the focus of the trial chamber is the most significant tacit admission by the prosecution of the weakness of its case against Colonel Setako. In its brief, the prosecution underlined 8 aspects of Colonel Setako's career which they appear to consider to support their claim. The prosecution argued that his military career followed a meteoric rise from 1973 due to his membership of the privileged group of people of Hutu ethnicity from the northern part of Rwanda. They alleged that he had been recognized by governments of all times in his 23 years military career. They spoke of his position as a judge in the state security court, his position as director of criminal police, his membership or participation in GOM, his alleged position as a member of the Permanent Commission on Security, so on and so forth. The meteoric career of Colonel Setako is not due to his friendship to anyone or his origins. It is due to his merit. The prosecution argued that after finishing second to last in his promotion, he had met witness KBX on a basketball court, had befriended him, and that had led to his career taking off. The prosecution is evacuating one important fact. Colonel Setako's marks might have placed him second to last in his class, but that promotion only counted 14 people, the 14 best people that the officers' school produced. There is evidence as to which position his fellow promotion students were eventually appointed to and how prestigious they were. Like I said there is evidence. There is no evidence. But one thing remains for certain. According to Exhibit P84, only 3 other members of that promotion were still alive in 1994, and they were all of equal or higher rank than Colonel Setako. They were General Kabiligi, Colonel Dengiginka, and Colonel Ntiziriyayo. None of them.
I think we need those names, perhaps.
No, sorry. General Kabiligi,
That's easy.
Colonel Ndengeyinka, November, Delta, Echo, November, G, can't recall, Echo, Yankee, India, November, Kilo, Alpha, and then Lieutenant Colonel Ntiziriyayo, November, T, E, Z, I, R, Y, A, Y, O.
Thank you.
The prosecution also suggested that Colonel Setako had been, and I quote the brief at paragraph 7, recognized by governments of all times in his 23 years military career. This is an absurd argument. In his 23 years military career, there was only one government. It was Juvenal Habyarimana's government. Even if it had been the case, it is important to recall that in 1992, when Rwandan political life actually opened up to a multiplicity of parties, Colonel Setako's career did not particularly deviate. He was still appointed by MDR prime ministers on GOM, demonstrating once again that there was no particular relationship between Colonel Setako and Hutus from the north or MRND affiliated people, just one very competent jurist. The prosecution also argues that his position as a judge of the State Security Court led him to try civilians and military personnel considered by the regime of President Habyarimana to be traitors or perpetrators of other security threats inside the Rwandan state or accomplices of the RPF. Once again, the prosecution makes assertions that are grounded neither in the evidence or, in this particular case, in reality. They clearly state in their brief, for instance, that Colonel Setako only served on that court until 1990. Yet they added that the court's mandate was also to try RPF accomplices. How can that be when the court ceased to exist before the RPF actually became an issue? The prosecution is also suggesting that Setako's appointment as director of communal police was the result of a courtesy from President Habyarimana in order for him to restructure that communal police. The defense's impression is that the prosecution is somewhat hinting at some sort of surviving relationship between Colonel Setako and the civil authority apparatus and the communal police that would have been maintained until 1994. Years went by between the moment Colonel Setako stopped being the director of communal police, and in any event, the defense would like to point out that none of the references quoted at footnote 21 in the prosecution's brief support the claim that Colonel Setako's nomination at the Ministry of Interior was a courtesy of any sort, whatever that would mean. Moreover, he was not assigned to that ministry to restructure the communal police. Witness KBX indicated that the quality of his work at the Ministry of Interior was the reason why the minister had decided to assign him that task. And I refer to you to page 9, lines 16 and 17 of the testimony of witness KBX. Moreover, there is absolutely nothing in the evidence in this case to suggest that his capacity as legal advisor to the Ministry of Interior put him in contact with any préfet or bourgmestre. On the contrary, the evidence and the remainder of the paragraph rather suggest that Setako was only in contact with the Minister of Interior, who himself managed the préfet and the bourgmestre. Now,
did you refer to footnote 21?
Yes.
On page 8 of the corrigendum. First of all, we note a difference between the English and the French version. Defense counsel is not referring to page 21, he's referring to footnote 21. But let us now see whether we can find that footnote.
Yes.
I may be wrong, but isn't footnote 21 just a reference to a transcript of 22nd June?
Personally, my corrigendum, I have a corrigendum that starts at page 41. It might be a confusion in the transmission of documents. The corrigendum that we received a few days after the brief itself did not have any modification before page 41. But that could be a problem on my part.
Assist you, I think my learned friend is actually referring to footnote number 20. It's on page 8. Footnote 21 refers to Setako's duties.
Look at paragraph 9 of the brief, Mr. Lucia Berdou.
Yes.
It starts with in 1987 by the courtesy of, and then in the fourth line we have until the end of 1990.
That is correct.
Footnote 20. Is that the relevant one?
Okay. It is the relevant one. In my version here, and I haven't made the correction, it is footnote 21.
Okay, thank you.
Now, the prosecution then proceeded to twist the evidence much further when they asserted that Colonel Setako had admitted that the reason why he had not been appointed as commander of the Nkumbas, and that is N-K-U-M-B-A, sector for Gom, was because of his, and I quote, Hutu extremist tendencies. Well, that statement is quite preposterous. One look at the transcripts of 22nd of June 2009, pages 35 to 37. Colonel Setako never said that. Colonel Setako only said that there had been opposition by the RPF to his nomination, but never made any sort of admission as to the reasons why. The prosecution also noted the participation at paragraph 11 of Colonel Setako to the Security Commission of the Communauté économique des pays des Grands Lacs. But there is no evidence that the Security Commission actually did anything. Now, Colonel Setako was admittedly appointed to that commission, but never did anything. Finally, the prosecution also made references to Colonel Setako as part of as a special investigator on behalf of the interim government at paragraph 13 to 17 of its brief. The defense would like to remind this court that Colonel Setako's testimony is clear, and there is no other evidence on that matter in the case. The investigations led by him during that period were regular ones. They were ordered by the Minister of Defense, and they pertained to the behavior on the battlefield of some military officers. These investigations merely aimed at determining if there were any problems with the behavior of those officers, not if they were traitors. The defense feels it is important to remind this trial chamber that, contrary to what the prosecution has been suggesting, the attentive review of the positions held by Colonel Setako throughout his career do not show the portrait of an extremist and opportunist whose career was due to his ethnic background, his commune of origin, or the friendships he had tied, but rather the career of an officer and jurist who was deemed by many to be worth of sitting on adjudicating organ not unlike this one, and who more than once put his life in danger in the name of various peace processes and ceasefire negotiation. It is true that Colonel Setako never made any mystery of his dislike of the RPF, but that never had been and never should be confused, contrary to what the prosecution tries to do, with a dislike of Tutsis as a whole, and certainly not with any form of genocidal intent. Thank you very much.
Thank you so much. Professor Hinds.
Thank you, Your Honor. In the 10 minutes that are left, I would just, with the indulgence of the court, like to make the following observations. This chamber knows, and the prosecutor was on notice of the defense's theory in this case concerning the fact that the events described by prosecution witnesses were not reflected on the ground during any of the parallel procedures in Rwanda. We made no secret of this. From the time I came onto this case and I began questioning witnesses, the chamber wanted to know initially, but what is the relevance of it? And we said this is our position. And we proceeded to introduce documents and subsequently called expert witnesses. Now, we would have expected, if there were any documentation available in Rwanda that established corroborative evidence through the parallel gacaca processes, establishing as a fact that Colonel Setako was involved in crimes claimed by prosecution witnesses, they would have produced it. I'm not saying that the prosecution office has unlimited means, but they certainly have more than the defense. The fact of the matter is the prosecution produced one exhibit, Exhibit 79, to attempt to impeach the defense expert, Bert Ingelaev. Now, what did that document show? It was a document that had handwritten one name, Setako. That's it. Of all of the documents throughout Rwanda, in Ruhengeri, in the Kigaliville area, nothing. But look at the document. I'm suggesting to the chamber, look at the document. And you'll see that there are 5 witnesses who testified here. These 5 witnesses were in prison. These 5 witnesses gave statements, and the statements were not statements that had to relate to whether there was ambiguity in the questions that were asked, and within the culture of Rwanda, they would answer questions in a very kind of myopic way. The document says that the witnesses were asked during this investigative stage to give statements, their statements, outlining the places where offenses were perpetrated, names of victims and perpetrators, names of those who made confessions and applied for pardon, names of those who were exculpated by fellow detainees. They were asked to give names with respect to offenses that were perpetrated. SAP gave statements, said nothing about Colonel Setako requesting weapons for training from Mukamira. SQG mentioned nothing about Setako's involvement in military training, etc. SAW didn't talk about any killings that took place in front of ISAE and implicating Setako. SAA did not mention anything about meetings at Zerero's mother's house. Didn't mention the killing of Bernard Bajagahe. Didn't mention military training of the Amahindure. But he did talk about him being on a committee to distribute Tutsi property. SAM, another witness, in this document that they presented, didn't mention anything about military training at the Gendarmerie, Ruhengeri. Didn't mention any military training at Nsimbi. Didn't talk about Setako training them with wooden machetes and wooden replicas of guns, etc. Didn't talk about the burning of this young Tutsi girl in Kuli. But we should recall what defense witness RBN talked about in the context of fabrication. And that these prisoners, while they were in prison, were asked to, during a sensitization process, bring evidence against certain individuals. Now, we did not have the document ahead of time so that we could use it at cross-examination, etc., was introduced by the prosecution during the testimony of the expert witness. And he said, yes, if Setako's name appears, it appears. I am not here as an advocate of one level or another. My position is that if certain crimes took place, they should have been recorded. If Setako is involved in those crimes, that should be recorded. If you have a document where you say Setako's name is mentioned, then it is what it's worth. I want to close by quoting Justice Robert Jackson at Nuremberg, because we have to deal with the legacy that we leave behind, those of us who are participating in this process. And I raised it at the beginning in the context of Alice in Wonderland. I am now closing with the context of the reality of Nuremberg and the footsteps that we are taking in the jurisprudence leading from that. Robert Jackson cautioned the justices at Nuremberg about fairness. And as you recall, I am just rephrasing it again for emphasis. He says, if we give these defendants, namely the Nazis in the dock, a poisoned chalice, we put it to our lips ourselves. Because that is the legacy we leave. Those of us on the defense side, my colleagues on the prosecutor's side, and you as judges. The evidence, the quality of the evidence that has been presented in this case is so lacking, raises so many questions. To convict Ephrem Setako based upon that type of evidence would raise more questions than provide answers. We have to have the courage to do what is right. I, as a defense lawyer, and my team, we raise questions. We trust that this chamber will evaluate it and come to the inescapable conclusion that if the prosecution has not met its burden, then Setako should be acquitted. Thank you very much.
Thank you to the defense team. We will then continue tomorrow morning with a very brief second round. And I think maybe if arrangements could be made by the translation department, that we have the Kinyarwandan interpreters with us in connection with the tendering of the document of the prosecution just for 5 minutes tomorrow from 8:45 to about 9 o'clock. And then we will come back to it, and then they may leave again. Professor Hinds?
Yes, Your Honor. I don't want to be premature, but the defense does not plan to take any more time unless my colleague on the other side intends to raise some issues that we feel constrained that we'll have to leap to our feet. But at this point, the defense is finished.